In the early days, you had a government telecasting company called Doordarshan, which projected a government point of view. It also had a lot of entertainment, and people would watch it. But it did not amount to freedom of information. But with this move that took place in the 90s, now you have a plethora of channels from within India. You have access to channels across the world. So India is not insulated in any way from information and from publicity, which is available anywhere in the world. Then you had initiatives of civil society. Civil society began to mobilize. With all these inputs that had come in, civil society began to mobilize. And Rajasthan, I have mentioned, Rajasthan is one of the states of India, in northern India, a very poor state, a very feudal state, a state with a feudal background, as I said, which is largely desert. But here you had a movement sparked off by the poverty alleviation programs, in which a young woman, now of course a much older woman, Aruna Roy, who has been awarded the Magsaysay Award, taking up the cause of those people who government had claimed had been actually paid for their work on these poverty alleviation programs, but had actually not been able to do any work at all, had not actually been employed. And the money that was supposed to have been paid to them had gone into lining pockets of various government functionaries or contractors. So to find out as to whether the payments were actually being made, whether the claims being made that so many people had been employed were actually well-founded, this movement was started. Not started as a movement by a few to find out about the many, but in motivating the many to find out about themselves. And therefore, they went and asked at the offices, at the government offices, which were assigned the task of actually running these programs, to show them the muster sheets, how many people were employed, who was paid how much. And the first response was, sorry, this is government information, this is not available to you, we can't give it to you. So this movement started. And this movement then led to a realization in the political leadership that this has become a demand. And the demand ultimately resulted in the Freedom of Information Act, which came about in 2002. But in the meantime, the press and the media had also begun to recognize, why don't you come to the front, this place here, had also begun to recognize its power, its potential, and begun to question and begun to ask. So taken together, this developed a kind of pressure on the political leadership that if they sought the support of the public, then they had to be able to make information in government accessible to the public. And in 2005, you had the Right to Information Act. This is what the Right to Information Act says. Democracy requires an informed citizenry and transparency of information. Professor Palmer was asking me about the concept of transparency. Transparency is built into the prelude of this act, which means that this is the objective of this act. Transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. Now, it's not only the government itself, but all its instrumentalities, which of course means government servants, but also means all those who are benefiting from government finance. I'll explain that in greater detail as we go along. How did the world develop in its quest for freedom of information? In 1776, you had the earliest concept of Freedom of Information Act, freedom of information actually made into a statutory power, and this is Sweden. This was made part of Sweden's constitution. This was followed, of course, not fast, but many years later, in fact, nearly 2 centuries later, by Finland, which brought in a law on the public character of official documents. Then Denmark and Norway had their acts in 1970s, which were also based on the Finnish pattern, which in itself is based on the Swedish pattern. In the USA, in the meantime, you had come up in 1966 with the Freedom of Information Act, which by an amendment of 1974, the onus of justifying restriction, earlier which lay on the person who would ask for the information, he had to justify that this information should be made accessible. But after that 1974 amendment, justification for restriction was laid totally on the government. The onus lay with government. And law places time limits for responding to requests, and all non-secret information is disclosable through the doctrine of severability. And I'll mention I'll go into details about severability as we go further. And disciplinary action was mandated against those who withheld information without justifiable cause. And all these clauses you will find have been brought into India's Right to Information Act. I had mentioned to you that various legal interpretations had held the right to information always subsisted under the Constitution of India. Here is the decision of the Supreme Court of India in a particular case, State of UP versus Rajasthan, as long back as 1975, in which Justice Matthew, on behalf of the bench, had this to say. Of course, this you can read. And finally, to cover with a veil of secrecy the common routine business is not in the interest of public. Therefore, the court had held that what is in the public interest is information that is accessible to the public. This had been established then, but took a long time to become law. Some people will of course say that it didn't take a terribly long time, because India has only been free for about half a century. The UK has had a democratic structure for centuries, and yet it is only in the year 2000 the UK has passed the Freedom of Information Act, and they gave themselves 5 years for actually bringing that act into force. It came into force only in January 2005. India, on the other hand, passed this act in June 2005 and enforced it in October 2005. So fast that the government of India itself was not quite ready. In fact, I myself, as Chief Information Commissioner of India, was only sworn in on the 27th of October. That is well after the law had actually come into force. If somebody had taken government to court and said, "Where's your Chief Information Commissioner?" they would have had no answer. Now, when the Prime Minister of India was introducing this bill in Parliament, this is what he had to say. And of course you can see that, but what is the core of the whole thing is an era which will bring the common man's concern to the heart of all processes of governance. I think that, you will agree, is the essence of democracy. A government that governs without concern for what the common man needs is not a democratic government. The common man's concern must be at the heart of governance in any democracy. And this is this is an act which sought to bring about this, and an era which will truly fulfill the hopes of the founding fathers of the Republic, the hopes of the founding fathers, the founding father I quoted to you earlier. Now, what is information? Information accessible under this Act has been clearly defined under the Right to Information Act, under Section 4 and under Section 2(1)(2)(f). Information means any material, in any form, including records, documents, memos, emails, opinions, advices, so on and so forth, logbooks. That means records of the use of government vehicles. If I am entitled to a staff car, for example, and I am entitled to use that staff car for all my official purposes, but if I start using that for all my private jaunts and that's put down, any citizen has the right to ask, what was this car used for from this time to this time? And he has to be given the answer. So it makes the public servant, the public authority, accountable to government. But, more important, any private body which can be accessed by public authority under any other law for the time being in force. Now, this is an interesting proposition, because in India, we have many laws under which many private organizations have to report back to government. Cooperative societies, for example. there's a Delhi Cooperative Societies Act under which the Registrar of Cooperative Societies has the right to access any information held by any cooperative society. What was actually happening was that if a person went under the Right to Information Act and asked for information from a society, the registrar would say, well, the society is not a public authority, so go and ask the society. So they'd go to ask the society, and the society would say that I'm not a public authority, therefore you have no right to ask me. But then when the matter came in appeal before me, I said, well, I'm very sorry. The fact is that the registrar has access to that information of the cooperative societies under the Delhi Cooperative Societies Act. And therefore, the information accessible to the society, to the registrar, has to be made available to any individual asking for it. The only difference is the person asking for the information need not go to the society directly, because the society can plead that I am not a public authority, therefore I do not come under the law. What is a public authority? I'll mention that to you later. But so that they can say that I am not a public authority, so I don't give you this information. But the department, which has access to that information, cannot make any such plea. With the result that the Cooperative Societies Department, which has only about 3 individuals, is now overridden with requests for information from all this regarding all their societies under their control, and they're hard put to provide that information. So they have passed an amendment to their law whereby they have declared that the cooperative societies are to be declared public authorities, so they can actually reduce the burden of actually supplying this information. Now, these are the key concepts: transparency and accountability in the working of every public authority, the right of any citizen of India to request access to information, and the corresponding duty of government to meet the request except the exempted information. There is some information which is exempted. And you will agree that transparency, even if it is given in government, cannot be total. There are certain interests of the state which may not be disclosed. But it is important to define what those interests are, so that a person cannot plead interests of the state just to deny information. And I'll come to that as we go on. It is the duty of the government to proactively make available key information to all. And this is where information technology comes in. When I mentioned to you the revolution in information technology which has taken place, its relevance, its relationship with this law comes in under Section 4 of this Act, and I'll describe to you in the next slide as to what that exactly is about. And then, of course, it is the responsibility of all citizens of India, the citizenry, NGOs, and media, as much as that of government. If this Act is to work successfully, then all sections of the people have to feel that they are participants. And this feeling, you will be happy to know, is already growing in India. The government of India had thought of bringing amendments to amend some of the Act to take some parts of the accessibility out of its jurisdiction. And there was such a widespread debate across the country, right down to the rural level, across the media, across the newspapers, that the government thought better of it and said we will only bring this law, this amendment, once we have discussed this with all stakeholders. And they have not brought that amendment since. Now, this is what I meant by the Section 4. Every public authority shall, 1, maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to inform information under this Act, and B, ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources computerized, but not only computerized, connected through a network all over the country. So that if Mr. Gill sitting in Salt Lake City wants to find out some information regarding a particular file back home in New Delhi, it should be possible for him to access that information sitting here. Ask for that information under the Right to Information Act, and the person there, the public information officer, can give him access to that particular record which he wishes to see. As you can understand, this is a revolutionary concept for India in many ways. In some ways not so. Because of our position in software technology and information technology, you may say it is not a revolution. But from the subsistence levels from which we have just risen very recently, it is a revolution. From a closed government, which was highly cloistered, to one which makes all its records available on computer and networked, is certainly, I think, a revolution. Now, I had mentioned public authority, and public authority. A public authority has also been defined in considerable detail. It means all those organs of government which come under the Constitution or laws made by any state assembly or a government notification, but it also includes any body owned, controlled, or substantially financed, or any non-government organization substantially financed directly or even indirectly by funds provided by government, which really would mean that those organizations which enjoy public funds are all answerable to the public. And this brings me back to my theme that this is an expression of democracy. Because in a democracy, it is the public which is government. And it's the representatives of the public which actually run the government. Therefore, if you accept that point of view, then the public has the right to all information to which the government has a right. And if the government has a right to any information because it has financed a certain organization, then the public also has that right. And how do you access it? You can inspect works, you can inspect documents, and you can inspect records. There have been instances where roads have been built, and the sanction order sanctioned a certain quality of material to be used in building those roads. But people in the neighborhood found the road had developed potholes within months of actually being laid. So they asked for information as to what were the materials used. They wanted samples of the materials. They saw the sanction orders. First they asked for the sanction orders. They saw the quality of the material sanctioned was very good. Then they said, we want to have samples of the material. They took samples of the material and had it tested. And it's interesting. But when in one of these cases, a party asked for an appointment to be able to take samples of the material. They were told, please wait for 15 days, we're a little busy. In 15 days, the whole road was relaid. And then they were asked, please come and take a sample. And when they came and took the sample, they found the sample was exactly equivalent to what the sanction was. So, but this kind of thing has been used also effectively. You can take notes, extracts, or certified copies of documents, take certified samples of material, and again, obtain information in the form of printouts, diskettes, floppies, tapes, video cassettes, or any other electronic mode, or through printouts. So the entire means of accessing the information has been placed at the disposal of the public. One party, I remember, had wanted to go and take video photographs and take videographs of the material which they had inspected. The department said, no, very sorry, videographs are not mentioned here. We can provide you videos, but you can't videograph. I said, this is a rather foolish argument. If he's saving you a cost by videographing it himself, he's taking his own video camera and filming it for himself, and therefore he must be allowed to do it. So now you can go and do that also. These are the processes. Applications can be submitted in writing, but they can also be submitted electronically. So you can type out your information and send it to the concerned public information officer who's been designated to answer this. It envisages a public information officer in each department or agency to receive requests and provide the information, and an assistant public information officer at the sub-district level. What has happened is the chief postmaster in every post office has been designated as an assistant public information officer for all the departments in the government of India. So if you're living in a rural area, you can go to the postmaster, give in your application there, pay your fees, and then expect your answer from that very assistant public information officer within the time limit which has been specified. And here are the time limits. Information has to be provided within 30 days. And if there is a danger to life or liberty, it has to be provided within 48 hours. Now, what is a danger to life and liberty? This has been a somewhat demanding proposition, so we've been asked to define it, and we have gone ahead and defined it. And it has to be, there's 35 days, but the maximum outer limit is 45 days. And of course, there's some information which is excluded. And this covers those agencies which are security agencies. I'll come to that in detail a little later. But if further fees are required, I would like to say here that if there are certain further costs in providing the information, those also will have to be borne by the person asking for the information. And for that, any time that is taken, but with his acceptance, his or her acceptance, the time taken between actually telling him or her that this is the amount that is due and her responding that, yes, I'm willing to pay this, that is excluded from within the time limit. And if there is no application taken, if there is no action taken for 30 days, it is deemed a deemed refusal. A deemed refusal means that the information is to be provided free of charge. That means no fees will be charged or no costs charged. And no fee for delayed response, as I said, section 7.6. And if there is a deemed refusal, that can amount to penalty also. But the penalty clause I'll come to later. The following is exempt from disclosure. I mentioned to you that there are certain items which are exempt from disclosure. Information disclosure which would prejudicially affect the sovereignty and integrity of India, security, strategic, scientific, or economic interests of the state. These are also included. And information which has been expressly forbidden to be published by any court of law, or information, the disclosure which would cause a breach of privilege in Parliament. In fact, the finance minister had rung me up just before the first year of the implementation of this act, and he was about to present his budget to Parliament. So he said that I'm being lambasted with a whole lot of requests saying that they want to know all the details of the budget even before it's presented. What do I do under the Right to Information Act? I said, sir, you're protected under this particular clause, because you don't have to reveal to the public before revealing to Parliament. Of course, after revealing to Parliament, you will have to reveal it to public, because that is the parliamentary privilege. And so, of course, as you will have noticed, the budgets are being presented without any let or hindrance. Now, this is the other interesting clause, so as to not damage commercial interest and genuine competition. Information of this nature, commercial confidence, trade secrets, or intellectual property, is not necessarily disclosable. But there is a qualification which would harm the competitive position of a third party, or unless the competent authority is satisfied that the larger public interest warrants the disclosure. So there is a certain amount of discretion involved in this. One has to see that the public interest comes first insofar as the protection of this right is concerned. Information available to a person in his fiduciary relationship. You know what a fiduciary relationship is: a relationship between a doctor and a patient, a banker and the banking agency, and so forth. And information received in confidence from a foreign government. Information which would impede the process of investigation or apprehension or prosecution of offenders. We have found that certain persons under prosecution for income tax evasion had sought to seek time by getting information from here under the Right to Information Act. There, of course, we've had to hold that if it impedes the process of investigation, it need not be given. At the same time, simply because a case is sub judice does not mean it can be denied to an applicant. Even if a case is sub judice and is not going to impede the process of investigation, that information has to be provided. Cabinet papers, including records of deliberations of the Council of Ministers. But here, too, there's a clause that says that once the cabinet decision is taken, then the information has to be disclosed as to why that decision was actually taken. And then, of course, there's a question of invasion of privacy. In the UK, you have a Data Protection Act. In India, you have no such act, but this is the clause which protects personal information or invasion of privacy. But earlier, you had an Official Secrets Act in 1923, which was the guiding principle behind secrecy in government. As you can see, in 1923, it was a colonial act. If you read that act, you will see that the act was designed to protect the government from the public. Now that you have a democracy, and the public is in fact the government, you can't protect the government from itself. So the Official Secrets Act has been overridden, but it's not abrogated or withdrawn. It's only been overridden insofar as being inconsistent with the Right to Information Act. And here under Section 8 specifically, if the public interest in disclosure outweighs the harm to the protected interest, even if it is protected under the under the Official Secrets Act, that information can be disclosed. That discretion lies with the department concerned. These are the further exemptions. Copyright is exempted, but state copyright is not exempted. The state cannot plead copyright for denying information. Where practical, part of a record can be released. This is the severability clause, which I mentioned is there in the US Act also, which means that if part of the information is confidential or falls under Section 8, and a person wants information other than that, but which comes from the same note sheet or the same correspondence, then that portion of the information is to be provided, which is not undisclosable. Intelligence and security agencies are exempt. This is under Section 24. But if there are cases of corruption and human rights violation, they are not exempt. Third-party information, this is again protection of privacy. Third-party information is to be released only after giving notice to the third party. And most exempt information is to be released after 20 years. There are some exceptions, but most information can be released. In fact, I've been having many reporters coming and meeting me. They've been wanting to report about the 1971 war between India and Pakistan, the 1965 war between India and Pakistan, the material of which has been held in confidence all these years and not disclosed. But now that is all disclosable under this particular act. And the information cannot be denied to the parliament or a state legislator shall not be denied to any person. In other words, the citizen has been raised to the level of being a member of parliament. And as I mentioned to you, the Official Secrets Act. Now, these are the various things which can be complained about. The Information Commission, the Central Information Commission, which I head, is an autonomous body set up to inquire into complaints received from citizens. You can complain you have been refused access to information. You can also complain about how the public authorities handled your request. And failure to respond to your request within 30 days, this can be the cause of a complaint. Failure to give you proper advice and help within the stipulated time, this can also be a cause of complaint. A failure to give information in the form in which you asked for it. If the form in which you asked for it is too bulky, then the public authority has the right to give it to you in another form, which is under Section 7(9). But if it's a simple form that you've asked for, then I have to give it to you in the form in which you ask for it. And failure to properly explain reasons for refusing your request. Every time the request is refused, a proper reason has to be conveyed that this is the reason for the failure to give this information. The penalties. These are only imposable by the Information Commission. And if there's unreasonable delay, a penalty of 250 rupees a day, up to a maximum of 25,000 rupees. And for illegitimate refusal to accept an application, or a malified denial, or knowingly providing wrong information, or destroying information, there is a fine imposable of 25,000 rupees, or there can be a recommendation made to the department to take disciplinary action under the law. There is no criminal liability, and there's immunity from legal action taken in good faith by the public authority, that is the public information officer appointed in each department. Access is universal. It is especially for the poor. Universal means for every Indian citizen. Under Section 3, this act is only open for Indian citizens. So if you, Professor Palmer, want some information out of this, you may have to go a longer route. But any person who is an Indian national, maybe an NRI in another country, can get this information. But inside India, it is universal. There is no fee for BPL. BPL is below poverty line. And as I mentioned, the assistant public information is located in the post offices. There is no need for specifying a reason for seeking information or other personal details. This is so also in the US Act. It is not so in the UK Act. In the UK Act, there are certain things which you can declare to be false and vexatious requests for application and deny the information to that person. Our neighboring country, Pakistan, has a Freedom of Information Ordinance 2002. They're a military dictatorship, so they don't have acts, they have an ordinance. Under that ordinance, the person who makes a false and vexatious application can be fined. The person who does not give the information can't be fined. So under our law, it is only the public information officer who can be fined. And there is a provision to provide all required assistance, including to disabled persons, even to the extent that it is in the law that if a person does not know how to write an application, the public information officer will write the application for him or her. And we have had a lot of people who are totally illiterate coming and seeing me. There's a provision for damages, and as I said, it is open to only citizens of India. It is supposed to be provided in all the local languages. This hasn't happened so far, but as you know, India has so many languages. Many of the states have already made such provisions of providing information in the local language of the state, but not all. Now, these are the responsibilities of public authorities. A public information officer and an assistant public information officer has to be appointed within 100 days of enactment, and this has happened in the Government of India level, but hasn't happened at the level of all state governments. And indexing, computerizing, and networking of records, which I mentioned, this has happened only to a limited level. Publishing within 120 days of enactment a whole set of information and updating it every year, this has happened. The set of information is regarding the functioning of every department. And publishing all relevant facts while formulating important policies or announcing the decisions which affect the public. This is also supposed to be published. This has not happened at all. Similarly, providing reasons for administrative or quasi-judicial decisions to affected persons has not happened. And providing information suo motu, that's section 4.2f, which I mentioned to you earlier, this has not really taken place to the extent in which it should have taken place. And providing information to the Information Commission, yes, this has happened, and we are supposed to prepare an annual report every year. The first annual report has been prepared. This has not been open to the public so far, because it has to be placed before Parliament, and we will be in breach of privilege of Parliament if we disclose it to the public. But this gives all the information about how the Act has been functioning in its first year. And raising awareness, education and training. This has happened insofar as in-service, within government facilities are concerned. There is a training program. The NGOs and the media have undertaken creating public awareness, although this is the responsibility of government under the Act. But this has not really taken place to the extent that it should have. And compiling in 18 months and updating regularly local language guide to information. As I said, this has happened only to a limited extent. This is the clause regarding awareness and educational programs, and the government is expected to develop educational programs to advance the understanding of the public, particularly the disadvantaged, to exercise the right to information. This has not happened on the side of government to that extent, but the media and the NGOs have played a salutary role in this regard. And encourage public authorities to participate in programs, promote timely and effective dissemination of accurate information on activities. On this, the government has made some progress. And train central public information officers and produce relevant training materials. On this, there has been considerable progress. Thank you. I'm afraid I've exceeded my time limit a little. That's why I had to rush through the last bit. But of course, you're welcome to any questions that you may have.
My name is Andrew Smith. I'm a Middle Eastern Studies major. Just at the end there, you were talking about portions of it that haven't been completely enacted yet. What is the projected timeline for finishing all of those projected?
This is an interesting question. You see, so far as we are concerned with hearing appeals and complaints and monitoring the progress. Now, in this annual report, we made a number of recommendations to government, pointing out those areas where progress is not satisfactory. Now, it is really for government to try and speed up that whole process, and for Parliament to ensure, in its review of our annual report, that the directions are issued to government to do so. I don't expect that it will take very long because, as I said, a lot of public awareness has already grown, and there's a lot of public awareness and public pressure on government as a result. But I will not be able to give you a definite date by which all these things can be done, because they're not in my hands.
I'm impressed by the range and the scope of this measure of the Freedom of Information Act in India. However, I'm wondering if a state of emergency were to be declared in India, if this act would still take effect, and if it would be applicable in a state of emergency in India.
Well, that's something of a hypothetical question, but I can understand why you asked it, because India has been through a state of emergency once. I don't think there's any possibility of a state of emergency being declared ever again. But if on the unanticipated question that would be imposed at some point, the emergency is something that is declared under the Constitution of India, and the Constitution of India has an overriding effect over all other laws, and therefore it would be the Constitution that would prevail and not any individual law. Although this particular law overrides all other laws in matters inconsistent with this law, which existed at the time that this law was brought into force. But that, as I said, does not mean that it will override any clause of the Constitution. But again, as I said, I don't anticipate that the emergency of the nature that was declared in 1975 can ever be declared again. And if there's a state emergency, then this act will continue to be prominent because it's a central act.
You mentioned that in other countries like the UK, it took over a few centuries to have a Right to Information Act, and whereas in India it only took close to half a century. Would you recommend that for new developing democracies, whether in the Middle East or in Africa, as they develop, have a Right to Information Act as early as they can in their history? Or
very strongly. I'd recommend it very strongly, because democracy does not simply mean that you have elections and every few years and you have a set of people you elect to rule you, which is what Mahatma Gandhi defined as Swaraj. Democracy should mean that people have a sense of participation in their own government. And if there's a better way of giving them that sense of participation than the right to information, then I have yet to hear of it. In India, for example, we've had a 73rd and 74th Amendment to our Constitution about 10 years ago, which brought down government right down to the village level. But even if that happened, all the people were not enjoying the fullness of democracy, which even that could have brought. Why? Because it was found that many of the activities undertaken by these local councils were being kept so confidential, so under wraps, they'd also become a source of corruption. And the people were not participating in that whole process, even though the law mandates that they should. It mandates that the entire village community should meet at least 2 or 3 times a year to monitor the progress made by their own village councils. It was not happening. Under the right to information, it has become incumbent on those village councils to place either on their boards or on the computers all the information regarding their development activities. I have in fact been around the country and met representatives of local governments. The first time I went to a far-off township in the state of Madhya Pradesh and to address the representatives of the local councils, and the lady who was the head of the district level local council came up and said that, you see, this act, we don't see that it's brought us any benefit, because when we ask for any information we are not getting it. So I said, I'm very sorry, madam, but you're not supposed to be asking for information. You're supposed to be giving the information. And you are here to tell me whether people have come to ask you for information, what information have you given them? So she said, I'm glad you told me, because my own impression was this is a means whereby I would get information out of the government. So I said, you are the government so far as the village is concerned, and you must provide the information to the villagers. So this kind of conceptual change will only come if you have a Right to Information Act, even if you have all the trappings of democracy. Democracy, in my view, will still not really be democracy unless you have this right.